Okay, let's unpack this. We usually have a pretty specific image in our heads when we hear the word solicitation in a criminal context, right?
Oh, yeah, for sure.
You picture, I don't know, a smoky room, maybe a hushed conversation in the back of a dive bar.
Yeah.
One person slides a thick envelope of cash across the table to a hitman or a drug dealer and says, do the job.
Right.
It's a transaction. Two people, both knowing exactly what they're getting into, agreeing to commit a crime.
Precisely. That's the classic archetype. It implies a meeting of the minds, a conspiracy born in the shadows where both parties are equally culpable.
But here's where it gets really interesting. What if the person across the table, what if they have absolutely no idea they're committing a crime? What if you hire someone to carry a package or flip a switch or deliver a drink and they think they're just doing a normal everyday job? Can you still be guilty of soliciting them if they're completely innocent?
And that is the central question we're tackling today. It's a fascinating legal puzzle involving a doctrine we call the innocent agent. It forces us to ask, does the crime of solicitation require two criminals or, just one manipulator?
Today we're diving deep into the case of State v. Bush, a 1981 decision from the Supreme Court of Montana. And honestly, this case plays out like a Hollywood thriller. We're talking fake identities, international travel to Peru, hidden compartments and camera cases.
It's unbelievable.
But legally, it challenges everything we thought we knew about the relationship between the mastermind and the pawn.
It certainly does. And to really understand the magnitude of State v. Bush, we have a specific roadmap to follow. First, we need to understand the doctrine of criminal solicitation itself, what it is and why it exists.
Right.
Second, we have to look at the sharp, almost contradictory divide between the old common law traditions and modern statutory interpretation regarding these innocent agents. And finally, we'll dissect the case itself to see how the court redefined the solicitor's intent versus the solicitee's knowledge.
So let's start with the basics before we get to the international intrigue. What exactly is the definition of criminal solicitation? Because in my head, it just means asking someone to do something bad.
It's a bit more nuanced than that. Generally speaking, the general rule of solicitation has two core components. First, you have the act.
Yeah.
This is the behavior of asking, encouraging, inducing, or, requesting another person to engage in specific conduct. You're actively trying to get someone else to do the dirty work.
Right. So it's the recruitment and the second part.
The second component is the intent. It's not enough to just ask loosely. You must possess the specific intent that the crime actually be committed. You aren't just joking around, you want the result.
Okay, that seems straightforward enough.
Right.
If I pay a guy to rob a bank, I performed the act of asking, and I intended for the bank to be robbed. Simple. But here's the testing question, and this is where my brain starts to hurt a little. If the person I solicited is innocent, let's say I tricked them into walking into the bank and grabbing the money thinking it was theirs, does the crime of solicitation still exist?
This is where we hit that historical friction point, and it's where a lot of law students trip up. We have to look at the common law rule. Traditionally, at common law, using an innocent agent was not considered solicitation. It was considered an attempt.
Whoa, stop there. That sounds like a semantic trap. If I pay you to burn down a house, I solicited you. If I trick you into burning down a house, I'm still the one who made it happen. Why would the law treat those differently? That feels like a loophole.
It all comes down to the definition of partnership. The old common law viewed solicitation as a meeting of the minds, two criminals agreeing to do bad things. But if I trick you, you aren't a criminal. You're just a tool.
Like hammer.
Exactly. If I throw a hammer through a window, I didn't solicit the hammer. I just used it. The old law said an innocent human is just a tool, like that hammer. So under common law, if I use a confused human to break the window, the law views that human as just a long arm of the defendant.
Wow.
I am the principal actor attempting the crime, but I'm not soliciting another criminal because there is no other criminal there.
That is a subtle but huge distinction. So common law says you didn't solicit a criminal, you just tried to commit a crime using a human tool. But doesn't that let the manipulator off the hook?
In a way, yes, at least for the specific charge of solicitation. But we have to contrast that with the modern rule, which is what we see in Montana in the State v. Bush case. Modern statutes can and often do change the common law.
Okay.
Under the modern view, the defense that the solicitee is unaware is often considered invalid.
So the focus shifts.
Completely. The focus shifts entirely to the solicitor's intent. The law basically says, we don't care if the person you hired was innocent. You tried to induce a crime, and that makes you guilty of solicitation.
I think I need a visceral hypothetical to really lock this in, because the difference between attempt and solicitation sounds technical, but I have a feeling it matters a lot in court. Can you give us a scenario that highlights the difference between these two rules?
I can. Let's call this the poison latte hypothetical. Imagine a man wants to poison his enemy. He goes to a busy coffee shop, hands a barista a vial of arsenic, and tells her with a straight face, "This is a new organic sugar substitute. Please put it in that customer's drink."
Okay, classic villain move. And the barista.
She believes him. She thinks it's sugar. She serves the drink. She is the innocent agent.
So how does the law handle the man?
Under common law, the man is guilty of attempted murder. He used the barista as a tool or a weapon, just like he would use a gun. But, and this is key, he is likely not guilty of solicitation because he didn't ask her to murder anyone. He asked her to serve sugar. There's no criminal agreement between them.
That feels incredibly technical. He's the bad guy in both scenarios.
He is, but prosecutors have to charge the right crime. If they charge him with solicitation under common law, he walks free.
Wow.
But under the modern rule, or the Montana rule, that man is guilty of solicitation. Why? Because he facilitated the offense, and he had the intent. The fact that the barista was clueless doesn't let him off the hook for the crime of solicitation. He solicited the act with criminal intent.
That clears it up. The modern rule closes that loophole where the mastermind could say, hey, I didn't solicit a crime, I just lied to a barista. Okay, with that framework in mind, let's analyze State v. Bush. This case is wild, and I want to really get into the story of the victim here, Kathleen Coase.
It really is a tragic story of manipulation.
So let's analyze State v. Bush. First, what are the legally dispositive facts? Paint the picture for us.
The story begins in September 1980 at a place called Carmen's Lounge in Kalispell, Montana. The defendant, Edward Bush, met a woman named Kathleen Coase. She was working as a bartender there, probably just trying to make ends meet. Bush came in and essentially spun a fantasy. He told her he was a filmmaker who traveled the world photographing animals.
Filmmaker. It's such a classic con. It promises glamour, travel, excitement.
Right. And he didn't just mention it casually. He actively recruited her. He told her he had a job opening for a film career. But he didn't stop there. To make it look legitimate, he created a whole theater of deception.
How so?
He used a fake secretary. He sent her official-looking application forms. He even had the secretary call Coase at the bar to confirm details.
He really committed to the bit. He was directing a scene before they even left Montana.
He was. And Coase, she bought it. She was convinced. She quit her job at the bar, which is a huge step for her.
Yeah, huge risk.
She was told a ticket to Los Angeles was waiting for her. She flew to LA and met Bush at the airport, but once she got there, the script flipped. Bush told her she wasn't going to be a courier anymore, she was going to be a photographer.
Talk about a red flag. Hey, you're not delivering the mail anymore, now you're flying the plane. But she stayed.
She did. I mean, she was already in LA, she'd quit her job. Bush gave her a crash course in using cameras, despite her having no experience. He gave her 3 cameras, $1,200 in cash, and a specific, heavy aluminum camera case. Then, he sent her on a mission to Lima, Peru.
From Kalispell to Lima, just like that.
Exactly. She flew to Peru. There, she met a contact named Dan. Dan took her to a zoo, ostensibly to take pictures of animals. But while she was at the zoo, Dan took the camera case.
He took it.
He took it, and he returned it later. After 4 days in Lima, she was told to return to the States.
And I assume this is where the innocent agent problem arises.
Yes. When Coase arrived back in Los Angeles, she went through customs. Agents inspected that aluminum camera case and found cocaine hidden in a compartment in the lining.
Oh, no.
Coase was arrested on the spot. She testified she had absolutely no knowledge of the drugs, didn't see them placed there, and thought she was just transporting film equipment.
So Bush set her up completely. He ruined this woman's life to move some product.
Precisely. Bush was charged with solicitation to possess dangerous drugs.
And what was the core legal issue?
The issue was whether the crime of solicitation is complete when the person solicited, in this case, Coase, is unaware of the solicitor's criminal purpose and scheme. Bush's lawyers essentially argued, how could I have solicited her to possess drugs if she didn't know she was possessing drugs?
That brings us to the law. We need the specific rule here. What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
So the court applied the Montana statute on solicitation. This isn't common law. This is statutory law. This rule has 3 main components we need to analyze.
Okay.
First, element 1, the act, the defendant facilitates the commission of an offense. Second, element 2, the intent. The defendant has the purpose or intent to promote the commission of that offense. And third, element 3, the negative defense analysis. This involves the statutory interpretation of whether the law requires the solicitee to be aware of the criminal nature of the conduct.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step, because this is where the court really dissects Bush's defense. How did the court apply the first element, facilitation?
All right, here's the analysis for the act of facilitation. The sub-issue was, did Bush's actions constitute facilitation or inducement?
Right.
For the analysis, the court looked at the objective facts of Bush's conduct. He didn't just ask, he actively recruited Kos. He provided the job, the plane ticket, the $1,200, and most importantly, the camera case, which contained the hidden compartment for the drugs.
He gave her everything she needed.
He provided the physical means for the crime to occur. So the conclusion, yes, his actions clearly facilitated the potential commission of possessing dangerous drugs.
Understood. He provided the gear and the cash. Now, what about the second element, the intent? Because he claimed he was just a filmmaker, right? How do you prove what was in his head?
That's always the hardest part, but let's look at the analysis for intent. The sub-issue. Did Bush possess the requisite criminal intent to promote the offense? For the analysis, the court examined the elaborate nature of the scheme. You don't create a fake secretary, a fake job description, and a hidden compartment in a camera case if you're just taking pictures of llamas.
Fair point.
The court noted that the gravamen, or the heavy weight of the offense of solicitation, is the intent of the solicitor. The complexity of the ruse proved his specific purpose. So the conclusion, yes, Bush absolutely intended for the drugs to be possessed and transported.
Now, here's the crucial conflict. This is the moment of truth for the common law versus modern rule debate. The third element regarding the solicitee's knowledge. How did the court analyze the innocent agent defense?
This is the pivot point where the court rejects the old way of thinking. Here's the analysis. The sub-issue. Is it a valid defense that Kos, the victim, did not know she was carrying drugs?
The core of his argument.
Right. So for the analysis, Bush's legal team argued that under common law, this scenario is not solicitation because the agent, Kos, was innocent. The court acknowledged the common law rule, but stated that the Montana legislature had affirmatively changed it.
They wrote a new rule.
They did. The court looked at the statute's specific language, facilitates the commission. This wording does not imply that the person solicited must be aware, but then the court went further to explain the policy reason, and this is important.
Okay.
The purpose of the statute is to protect citizens from victimization and from exposure to inducements to commit crime. If the court required the victim to be in on it, it would defeat the purpose of the law. It would protect the manipulator and punish the manipulated.
That makes perfect sense.
So, the conclusion. The defense fails. The solicitee's lack of knowledge is irrelevant under the Montana statute.
I love that policy argument. Basically, the court said, we aren't going to let you use the law to victimize people. And after analyzing all the elements, what was the court's final conclusion?
The Supreme Court of Montana affirmed the conviction. Edward Bush is guilty of solicitation to possess dangerous drugs, even though Kathleen Kos was an innocent agent.
So what does this all mean? If we're trying to spot this issue in the future, maybe on an exam or just reading a news story, how do we break it down? Give us the diagnostic checklist.
Okay, if you're looking at a fact pattern like this, you need a synthesis of these rules. Here's your checklist. 1. Identify the solicitor's conduct. First, look for the setup. Is there recruitment, encouragement? Are they providing the means, like money, tickets, or equipment? That's the act. 2, verify solicitor's intent. This is the gravamen. Does the solicitor specifically intend for the crime to happen? Look for the planning, the deception, the steps taken to ensure the crime succeeds.
Right, the fake secretary.
Exactly. 3, check solicity's knowledge. This is your fork in the road. If the solicity KNOWS and agrees, you might be looking at conspiracy. But if the solicity is unaware, an innocent agent, you have to check the jurisdiction. If common law applies, it's attempt, not solicitation. Remember the hammer analogy.
Right.
If a modern statute like Montana's applies, it IS solicitation.
And number 4.
4 is your policy tiebreaker. Finally, remember the policy. Modern statutes prioritize protecting the innocent from being used or victimized over preserving technical common law definitions.
It really is a fascinating shift. Bush tried to hide behind a technicality of common law, basically saying, I can't be guilty of asking her to commit a crime because she didn't know it was a crime. But the court ensured the law evolved to cover exactly that kind of manipulation.
Exactly. And it leaves us with a sobering thought. We often fear the criminal hiding in the alleyway, the one with the knife or the gun, but perhaps the most dangerous criminals aren't just those who commit violent acts themselves. The most dangerous might be those who have the intellect and the malice to trick good, innocent people into becoming instruments of crime.
It's a terrifying thought. The idea that you could be the weapon without even knowing it. And for Kathleen Coase, that wasn't a hypothetical, it was her reality.
Thanks for listening to The Deep Dive. We'll see you next time.